We are living in times where relationships are now very calculated and contracted. We always have the highest hopes for that fairy tale wedding and marriage and stories, but in reality, more than likely, you will need to get the help of legal counsel when life throws you a curveball. I sat down with Michael Alber of the Law Offices of Michael Alber, who is very well versed in prenups, divorce, family law, criminal law, and civil litigation to give you some preemptive advice on what to do if the shit hits the fan in your fairy tale. Now, let's get to business. I am here today with Michael Alber of the Law Offices of Michael Alber in Huntington Station, New York, correct?
Huntington, Jericho, and Bayshore. We have 3 offices.
Okay, and you practice criminal defense, divorce and family law, and civil litigation. So you have got all of the bases covered that we're going to talk about today.
Yes.
All righty, let's dive into it. You get into a relationship, everything's warm and fuzzy and everything. When do you have that conversation, if you are thinking about marriage, about prenuptial agreements?
Pretty quickly. Pretty quickly. And the reason why is because that can be a deal breaker for some people. That can be a formality that people get uncomfortable with. We've had prenuptial agreements where people thought they were going to be getting happily ever after married, and then all of a sudden they realized there are some real issues that they never possibly thought about. For the most part, though, prenuptial agreements work if you have like-minded individuals that understand the concept of, hey, this is for both of our protections. This is not for anybody to get a particular advantage. This is just to protect us in the event that there is dissolution of the marriage.
A lot of people are just flat out skipping marriage now, just to keep all of those assets separate, especially a lot of women having higher earning jobs now and everything. They don't want that dissolution to happen and have their assets put on the line for the other person. What do you suggest to them, though, as some of their assets may become combined and bigger?
If you're not going to get married with respect to growing a particular relationship or family, I think that one of the things that people need to consider is possibly having a contract. I think it's still enforceable to have a contract, especially as it relates to who will get what in the event of some issue. So I still think it's important. We see far too many circumstances where people grow a family, they're not married, they go on the deed to the home, and then all of a sudden they're realizing, wait a second, who's going to leave? How are we going to divide this asset? And that would be a subject under New York law to a partition action. So that's one of the things that's kind of difficult. But if they have an agreement that, hey, that asset will get sold, or hey, this is what the cuts are going to be, it's going to eliminate the fighting later on down the road.
When someone feels that a marriage is dissolving, when should they start sitting down with lawyers, and how do they go through the process of picking a lawyer?
After counseling. So I think that many people will get emotional with respect to a fight or a couple of fights, but really if there's a significant deterioration where there's zero communication going on and there's an attempt at counseling and counseling is just failing, at that moment, I would say, is the moment to contact an attorney. When selecting a lawyer, they should select a lawyer as to whether, one, that lawyer is battle tested, whether or not they've actually litigated the particular issues or dealt with the particular issues in a high conflict situation. 2, whether or not that lawyer is responsible in getting back to people, whether or not they call people back, whether or not they're reliable by communication. Communication is huge when it comes to a divorce. There needs to be an open line of communication between the client and the lawyer. And lawyers fail in that category all the time. One of the biggest complaints people get about divorce lawyers, my lawyer didn't call me back. So that's an area where if you really find a lawyer that will communicate with you, you're much more likely to get success.
A lot of times children are put right in the middle of divorces, and it's really heinous to see it happen. But What are your suggestions to people when they go through a divorce as to handling the children? Because we're seeing it right now with Joe Jonas and Sophie Turner. It's a real mess with those kids.
So I think really the saying goes, love your children more than you hate your spouse. Because if you have that much hatred for a spouse that you can't communicate or co-parent with a particular spouse or soon to be ex-spouse, you need to love your children more to be able to do that. So the first step is putting ego aside, putting your self-interest aside. It's always the best interest of the children that's paramount concern, not what's better for me as a parent. That's not the standard, especially under New York law. So I tell people, when you're going through a high conflict custody case, you really have to display an acceptance of responsibility for any faults that you may have. Seek to rehabilitate yourself if you need some type of therapy or rehabilitation with respect to an issue because you're struggling with something. And 3, facilitate contact with the other parent. Be able to communicate with them. Don't unilaterally make decisions. If you unilaterally make decisions without involving the other parent, you'll put yourself in a position where you'll be deemed to be somebody that's not willing to foster a relationship with the other side, which under New York law is a major factor of consideration when the court awards custody to one party or another.
Taking that into consideration, go a little deeper with that as to how parents need to handle that conflict when one is more of a power hungry person and just wants the power and they're using that child as a pawn.
If that's in fact happening, it may be necessary in that type of case where there's consideration of conducting a court-ordered forensic evaluation in order to be able to uncover what particularly is going on with that parent's roadblocks to co-parenting. 2, if a particular side is power hungry, and this case is in court, the attorney should seek an emergency conference if there are issues with making decisions. Get the court involved as early as possible, because that may influence the party that is putting up all the roadblocks. 3, make an application to the court restricting parenting time access and or having a court order that absolutely puts away all those roadblocks. Court orders put people in line. They have people follow a regular schedule and follow rules. And I think that's one of the ways to deal with it.
Let's delve into some of the issues that we have seen with celebrities, especially a big one with Danny Masterson and Bijou Phillips. Danny was just convicted and sentenced to 30 years in prison for past rape situations in Hollywood. And now Bijou Phillips is filing for divorce to protect those assets from being paid out, I guess, to the victims.
Yeah, she's already too late. So what she should have done was file for divorce immediately upon the allegations coming about where there was going to be any truth to the particular allegation. If she genuinely believed certain issues with respect to that really he didn't commit the crimes or he's completely innocent, then she would have stood by his side. Now, after a conviction, she would have stood by his side. Now, she's not. So as a result of having to go to file for divorce after the convictions already come in, that's going to put her in a precarious position to fight for particular assets. You're going to have victims that are going to step forward with lawyers that they've already had lawyered up, that are going to look to put liens on assets and or make emergency motions to the court in order to get their share. I think it's still going to be difficult for the victims to pierce her share in the marital estate with respect to trying to collect on it in judgment. So I still think she'll prevail, but divorce may have been filed a lot sooner, contingent upon the circumstance.
We're seeing a lot with that entire issue of celebrities that have taken certain sides that are now having to step down from their positions when these people are being found guilty in that kind of situation, which can also tear relationships apart. What do you suggest to people when they are on that side of the coin where those allegations are coming at them?
So you mean the actual accused themselves or the spouse?
Mm-hmm.
Accused
The spouse. The spouse.
So In this type of situation, when the spouse has to make decisions to, one, get a lawyer immediately, two, have a very transparent conversation with their existing spouse, who is the accused, to figure out the best way that they may need to protect the family, and particularly the marital estate. You can't commit collusion or fraud on a court, but there are times where a divorce may be called for the protection of interest, and or there may be a breakdown in the marriage. I can tell you, if a spouse is accused of a crime and the other spouse thinks that that crime is justified, or that this may have happened, or they did their own independent research, they should get a lawyer immediately, and they should consider filing immediately as opposed to waiting.
How ironclad are those prenups when you go into a situation with someone and say they get a really good lawyer and they want to keep fighting that prenup?
So they're ironclad. If they're acknowledged under New York state law, if they're fleshed out where they have the right contractual language with respect to consideration in the agreement. One of the biggest aspects of contesting a prenup is a lack of representation on one side, meaning that one side went into the prenuptial agreement without having a lawyer. And two, getting too close to the wedding, and it's a duress issue. I felt pressured. I felt forced. The wedding date was Saturday. We signed the prenuptial agreement on Friday. Those are avenues that are going to cause an issue with respect to being able to blow open a prenup on the basis of duress or coercion. Unconscionability is a rare claim, which is a claim that one side got too much of a big advantage over the other with respect to the agreement. Many judges will say, you signed it. You read it, you signed it. It says here you read it. It says here you signed it. So people have to take this process really seriously, but for the most part, they are ironclad.
Another question about a lot of the marriages we see between, say, a older man and a younger woman who all of a sudden walks in and gets all of the things that the family thought they were getting with after the passing of the spouse.
Yep.
Have you seen many fights with that?
Yes.
And how do you deal with that as a family?
So a family that comes in, whereupon, let's say, an older spouse married a younger spouse, the older spouse passes, the younger spouse says, hey, I'm entitled to certain items, or I'm entitled to certain things pursuant to the, being either the wife or the judgment of divorce, and the family says, wait a second, no, we're entitled to certain things because of XYZ will that was left. It's going to be in a state litigation. They're going to fight it out at some type of court with respect to doing surrogate court litigation to see who's going to get what. That could get extremely nasty. We have one such case where there was a pending guardianship proceeding, whereupon it was perceived that the wife had taken advantage of the husband and marrying the husband 10 years prior, and that the husband didn't have the right capacity to be able to enter into a prenuptial agreement, which gave the wife a significant amount of money, and two, that he had no capacity with respect to entering the marriage. That case is currently being litigated and is going up on appeal. But there was an application sought to annul the marriage by the sister of the elderly spouse. So in those situations, you can get yourself in a real fight.
Let's talk about annulments, because some people don't know the difference between how to get a marriage annulled and just going for a straight divorce and all of that jargon.
Annulments are rare. You have to allege some aspect of fraud or something that happened with specificity prior to the entry of the marriage. Annul means as though it never happened before. So this marriage did not happen. It involves a strong inquiry from the court to determine whether or not the grounds that are alleged are in fact sufficient grounds. So annulment, as though it never happened. Divorces, it happened, but we're dissolving.
Let's handle situations of abuse also, because a lot of times, as we're seeing with these rape cases and situations like that, a lot of times a victim does not want to come forward, doesn't want to admit that their spouse or a family member is doing this to them. What is a suggestion to, say, a spouse who is in a very abusive relationship regarding, I guess, cataloging abuse and how to deal with that?
So catalog abuse, you can take recordings. I recommend not taking recordings of children. No good. Don't record your children saying, daddy hit me, right? Or mommy hit me, right? And who do you want to live with? And that's a no-no, but you can document by way of having some type of recording. I don't recommend planting recordings in intimate areas of the home because you could be charged with a crime for doing that. But under New York law, you're permitted to absolutely record a spouse that's screaming, cursing at you, and or getting physically violent with you. So definitely documenting. One of the other ways to document is by contacting the police department, filing a police report, or going to family court to pursue an order of protection. You actually have an obligation, if you have children, really to take those active steps, because if domestic violence is happening in the house, that parent should be taking active steps by getting court intervention, by seeking an order of protection and or expulsion of that spouse from the home. So those steps need to be happen. Otherwise, that parent can fall at risk of actually getting indicated for neglect or abuse on the basis of their failure to act on behalf of the children. So you have to take proactive steps.
How quickly should that happen? Because a lot of times these people aren't coming out and saying, hey, I'm going to abuse you. Hey, I'm going to cheat on you. Hey, I'm going to do all this stuff to you, you know?
So delayed disclosure happens a lot, a real lot. Abusive cycle relationships, delayed disclosure is going to happen where people are not going to want to come forward. They have to. One of the things that, that I recommend is immediately coming forward. Domestic violence is not acceptable in the home, period. Nobody has the right to have, to put their hands on you, punch you, kick you, do something to you in that fashion. It's just not acceptable. If it happens once, it will happen again. So I tell people, take proactive steps. It's uncomfortable in the beginning. Nobody wants to go to court. They feel as though they'll be shamed. If they do, they're intimidated by the court process because of the judge and the process. And, oh my God, I have to go to court. I don't want the fighting. I don't want to get cross-examined by lawyers. Lawyers have in part wrecked that process. The court system has not dealt with that process properly. There are other avenues like crime victim advocates and victim advocates that are now starting to come into the court system more, which can help assist in that process. But definitely a proactive step of getting an order of protection is a must.
Okay, let's bring up a big one that has been in the news everywhere. Out of Georgia, Lindsay Shiver and her husband, everything that happened with that case. She claims abuse, but she in turn hired someone to kill her husband. And I don't know if you saw the videos. It was such a messed up situation when the police were actually called out because he found out that she was actually trying to kill him.
So in that type of case, there is a lot of work that's going to be done by way of a defense in that case, by way of the psychology behind what's going through Lindsay's mind as well as the mind of her husband at that time. Right, wrong, or indifferent, domestic violence victims can have reactions. So nobody knows what's going on inside of that home during the duration of the marriage or what's happened previously. Actively planning a murder or actively planning something like that, that means that that could take somebody to the brink, meaning that somebody had so much angst, pressure inside that they actually pushed themselves to do something like that. It's a sign of mental illness, potentially. It's a sign of a really abused victim. However, in society, it's not excused. You can't plot the murder of your spouse. So now, without having an adjudication in court and without obviously seeing the full picture and the full facts vetted under oath with witnesses, it's kind of difficult to prejudge the situation. But I'll tell you, any lawyer is going to have to dive very deeply into the relationship and psychology. It's an absolute must.
We just had a very, very big one of Johnny Depp and Amber Heard with that whole divorce and the abuse allegations with that. And on top of that, the gossip that came out from the news outlets also. How is that on you as a lawyer? How do you deal with that?
So a couple of things. One is on divorce and family law concepts, commenting on what are for the most part confidential proceedings. Yes, they're open courtrooms, but commenting on it on actual your litigations in the area of divorce and family law is tough. You really, as a lawyer, have to be very careful in commenting. As it pertains to rolling over into criminal allegations, if the government's going to make a comment, defense is that opens the door for any defense lawyer to come out and address the government's comment. And if it's not truthful, accurate, or skewed, then the lawyer can definitely make statements with respect to that. Statements by a lawyer and or party can be used in court proceedings, so you have to be very, very careful. So I advise litigants going through a media process, keep a close eye on the lawyer and whether or not the lawyer is seeking media attention as a result of it, because that could be to your detriment.
Which goes back to picking out those lawyers and the trust issue. How do you have a conversation with a first-time client as to what they're going through and how to be able to convey to you that they can trust you?
So first, 99% of divorce consults nowadays across New York, at least, are done by phone. Most are done by phone because of the nature of the pandemic and the change on society. Society is very much driven towards what can you do for me now? So that call is coming in. People are researching on it. They're going to call you now, and they want a now call. They want you on the phone, and they want you consulting with them. So I think as a lawyer, when you can get on the phone and hear people without interrupting them, people don't want to be interrupted. So when a client calls and they're going through, or prospective client calls and they're going through that difficult time, lawyers sometimes speak too much. So we tell them, like, stop talking, let the client speak, because they need to get certain things out. If you cut off their storyline, you're not getting engaged on their case. And you're not going to engage with them, and they're not going to engage with you.
Okay. Let's shift to family. A lot of times we're seeing a lot of kids getting in trouble right now, the family having to deal with it, especially with these school issues now, with gun issues now. As a parent with a child in these situations, how imperative is it for you to have some sort of a legal backup should that call come in that your kid did something?
It's happening a lot more often. Those calls are coming in a lot more often that your kid, that something happened at school or something drastic happened. So, legal backup is, you don't have to have a lawyer on retainer, but I would say if something's going on with your child, don't give authorization to the school district to speak to them or a school without you present. And typically, even with a parent present, I tell them, don't have your child making any comments with respect to an issue that happened at the school.
Okay, let's talk about bullying, because this is a huge issue right now of kids on both ends being a victim of bullying and the school not taking proper measurements to protect that child, or the child that is doing the bullying still being allowed to do what they're doing.
It's happening a lot more frequent now than ever. The internet is very bad for that. Social media, very bad for that. Schools need to take more of an active step. And what happens is, a lot of times is some schools will take the position of, it didn't happen during school, I can't really restrict that. And then some schools take the opposite position. It happened affecting a student, and therefore we have jurisdiction to deal with it. I would say, first, the slightest bit that any of that's going on, it needs to be brought to school district authorities, because then they're on notice. If they don't act when they're on notice, then they're liable. Period. End of story. There's going to be liability on behalf of the school district. And frankly, too many school districts, especially on Long Island, are not taking active steps to stop it. And what they do is, then when somebody lashes out, they say, well, you can't lash out, and that's inappropriate that you lashed out at the person that you were being bullied by. And then the bullier, their bullying gets excused. There's no equal accountability or a hold on accountability. And I think that, frankly, as from a notice perspective, if a parent has a child experiencing that, put the district on notice, because the second they don't do anything and it happens again, it's liability.
Okay, so the parent does have a lot of say with the school district itself.
Yes. I tell parents, your child's in public school, open your mouth, go to the school, ask for a meeting with the superintendent. You pay taxes in that district. Your kid goes to that district. Your kid goes to school. There's no reason why the school district can't do their job. They're supposed to secure the safety of students during the day. They're supposed to look out for students during the day. They're supposed to look out for your children. And if your child is being bullied and now to the detriment has psychological issues because of it, or something's going on, and the school district was put on notice because you did, and I would do it in writing, and I would do it by formal complaint, and I would do it by a meeting. And then I would use words like, I'm just putting you on notice. If it happens again, this is going to be an issue for us because our son or daughter is going through X. The school district has failed to act previously, and I'm bringing it to your attention because I'm requesting action. I would use words like, what plan does the district have for addressing this?
Okay.
I would say, what plan does the district have for addressing this?
You brought up social media being a very big aspect of the bullying issue itself. And a lot of parents now are documenting their meetings with school boards, and these things are going viral because the school boards feel that they have more power in the situation.
Yes. And it just goes back to, I think, students and social media is not being policed enough. I think electronics has caused a massive issue with respect to kids in this problem, from iPads to getting their first social media account, to TikTok, to Snapchat, to anything they can do to basically interact with other students on a unsecured or unpoliced environment. And I think, and it's going to cause an issue as it pertains to school boards, but frankly, school boards have a lot of power, but they don't have so much power at a deposition when one of them is getting deposed under oath as to why they received the notice and ignored it. So I just think that, with respect to dealing with school boards, if a parent is having an issue and has to deal with a school board, they should be really formal about it. They should get a lawyer. They should have the lawyer reach out to the school district's lawyer. They should hold people accountable with documentation, and they should make sure any notices are in writing.
With some of the law changes, especially with the legality of marijuana, the legality of gambling, and some of these issues being problems in the past with spouses or family members, what do you suggest to a spouse who may acquire a gambling addiction through legal gambling now?
That's interesting. So I have this issue in a case. So a spouse that engages in gambling to the point where they're gambling all this money away, or, we call it wasteful dissipation of assets. It's a failure to basically you're throwing money away without consideration. So if that's happening and you're in a marriage, you should immediately, if you don't want to get divorced, push your husband or wife into a postnuptial agreement. We need to come to an agreement now with respect to how we're dealing with these issues. These are debts that are going to be your debts in the event the marriage dissolves. These are issues that are going to be addressed by you. And by the way, all of the money that you've gambled away, I'm entitled to 50% of it. So it has to be actively addressed. It's definitely an issue. Like under New York state law, that would be considered wasteful dissipation of an asset, meaning it's being wastefully pushed away without any consideration. So gambling is an issue that comes up.
With wasteful dissipation in a marriage, cheating. If it comes to the head that a spouse is cheating and they're spending all of this marital money on someone else, how do you deal with that also?
So it's interesting because under New York law, nobody really cares about adultery. Sadly, it's still in the books, but nobody cares, meaning that judges don't really care. However, if money from the marriage is funding another lifestyle, the attorney should definitely do a financial accounting of that and seek the recoupment of money, for sure. Because that is definitely considered wasteful dissipation, that you are funding another relationship away from your family. We had a case where a doctor was living an alternative life. He had a completely different family. His wife was at home with the kids, and he would be getting home at 11 p.m. and 12 a.m. And she thought that he was working. No, he was with his other family. And during divorce proceedings, we sought to recoup a significant amount of money as a result of him funding a separate family other than his own, to the detriment of his own existing kids who were the subject of the divorce proceeding. That is something that is wasteful. People do it, but it definitely should be considered, and a lawyer should be prepared to argue it.
We're seeing that more and more and more. What do you say to the other person who does not know about the original family?
That's really tough. It's really, really, really hard. I mean, the spouse that we had represented was really going through a tough time. Almost considered even reconciling with him because of the level of pressure as a result of it. So I say in those cases, if you have led that big of a lie, you're in a position of, one, I think there might be mental illness to be able to lead that lie. And that could be a parental fitness issue as it impacts your judgment. And from the perspective of impacting your judgment, that may, to that level, that may not be something that's capable of rehabilitation. So if that happens, I tell people I would file for divorce. I mean, we're not homewreckers as divorce lawyers, but something like that, you're going to live in misery for a very long time.
Bringing that up with a spouse or significant other or a family member that gets in that deep in mental, as you may say, it may be mentally something that's going on with them. And as we brought up social media, we just had a very public matter in horse racing where two people were kind of bullying someone, and a very well-known trainer just slapped them both with a defamation lawsuit. As family members, if you are the spouse of one of the people getting slapped with the defamation lawsuit, and this person, because of social media, loses their employment, what do you suggest the spouse does, or the family members?
So because of the defamation case, it impacts the employment. Well, employment can impact child support, maintenance, which is spousal support, as well as how the dissolution of the marriage may occur. So if, for example, you're in an existing intact marriage and a defamation suit hits a spouse, it goes back to even the same allegations that you would have in a criminal case, where you as a spouse would have to make a decision family-wise as to whether or not you would commence a divorce action. If the defamation case is started because of an inter-family or interrelated issue, spouses have to be very careful about wanting another spouse to be hurt during that process, because again, if they're not working or they get unemployed because of something, and it was not caused by their own issues, you might have a difficult time collecting support in court. And there's something called imputation of income, where meaning a judge could consider, well, you caused the defamation suit, and therefore, it's your problem because you voluntarily relinquished your employment by engaging in wrongful conduct. But if it was instigated at the start from a spouse or a spouse's family member to be vindictive or an issue, it may be perceived differently. It might be perceived by a judge that maybe that spouse should have been more reserved and not filed that suit, or a family member on behalf of a spouse.
If you're on the receiving end of that, with all of everything going on, and you are already under so much pressure as to what the spouse did to begin with, would you suggest counseling first before dissolving the marriage or seeking legal action?
Counseling first. Always counseling first, because from a perspective of whether or not it will there's any hope of reconciliation in the marriage, that's a recommended step. Legally, though, from a legal protection, might be a little bit different. If there's a valid defamation suit that may encumber the estate, you may have to make a decision legally to say, okay, we're getting divorced, and you may need to file for divorce because that's what's best for the marriage. And your existing spouse who's getting sued may agree. So it's a very tough position, and every case is factually nuanced as to which way you would go. So the typical answer would be, hey, counseling first, yeah, despite the legal troubles, and then see if we can resolve the marriage. But if it's a lawsuit that's outside of the marriage that's impacting a spouse, the spouse that's not impacted, but may be impacted by it in the future, may need to consider getting out of the marriage and dissolving the marriage to get their fair share of the equitable estate.
Michael, you have answered so many different questions. I hope you have given our audience a great deal of knowledge as to what to do if they are in any of these situations. Well, how can people find you on social media?
Alberlegal.com is our website. Law offices of Michael J. Alber PC, which the firm is going to be changing names coming up. We're on TikTok, Instagram, Facebook. Even if they just Google my name or put Michael Alber into a search engine, they'll find us.
Okay, you deal primarily with New York. Do you ever deal in other states?
We're opening offices across the country. So in 10 years, we'll be in 50 states. We're on a plan to do, I think we're at like 25 states in 5. Over the next year, we'll be in, I think our opening plan is like 6 or 7 cities just in the next 8 months. So.
Michael, congratulations. And thank you so much for being on here with me to answer all of these questions. I am Tatiana Ryan. This is the Businessy Podcast, and this is Michael Alber.
Thank you so much. Have a great day.
You too.